Hey, everyone, welcome. We'll get started in a couple minutes. We're just waiting for a few more attendees to join. All right, so I know a few more people have joined. I think we've got another minute or so to go before noon. And we'll get started at 12 o'clock sharp. All right, well, it is 12 o'clock noon, everyone. Welcome. We'll get going here. Just be aware we are recording, so we can share this with those folks who weren't able to attend today. So please, as we go forward in this presentation, don't provide any confidential information, as this is going to be a public venue and will be circulated publicly. Happy to answer any questions or to touch base with you separately afterwards, and I will follow up via email after this presentation. But welcome, everyone. The other thing I'll mention is I'm handling sort of the tech in the background, so certainly appreciate your patience. If there's any technical difficulties, we'll try to get them ironed out as quickly as we can, but hopefully it'll go smoothly. All right, well, welcome to How to Position Your Startup for Venture Capital Funding. Let me go through a few preliminary matters first. General disclaimer, as you know, obviously I'm presenting a lot of general concepts and principles. We'll have a Q&A session towards the end, but just want to make sure that everyone's aware that, don't consider anything we talk about as legal advice. Certainly not anything we say is not intended to or won't create any sort of attorney-client relationship. Oftentimes, the general principles and concepts we talk about are not going to be applicable to a specific situation. So I may answer some questions during the Q&A session, but certainly don't take that as legal advice. Obviously, I oftentimes will be answering questions, conceptually or theoretically, don't have all of the information or all of the facts. And to really get proper legal advice, you need to engage a lawyer, make sure you give them all of the details and facts and background, and then they can provide appropriate legal advice. But certainly feel free to reach out after the presentation if there's anything you want to ask and want to get into a little bit more specific information on. Okay, with that said, here's sort of a general overview from a legal perspective on how to position your company for venture capital financing. What we'll talk about, I'll give you a little background on myself and my practice. We'll talk about some general structural considerations when you're thinking about preparing your startup for VC financing. That'll include sort of general ideas on entity type, jurisdiction, what are the financing strategies, stages you might be thinking about, what is the documentation that we should be thinking about for founders and early employees. We'll have a general overview of safe investments and convertible debt investments. There'll be a general overview, discussion about valuation and dilution. We'll talk a bit about pro forma cap tables. And then we'll get into an overview of what a venture financing looks like, some of the processes and procedures and steps involved. We'll talk about how to prepare yourself for a closing of VC financing, what I call the ABC approach, which I'll explain in a little bit later. And then we'll talk about some common pitfalls that we sometimes see if things aren't done properly, and some missteps that hopefully we'll be able to point out to you and allow you to not fall into those same pitfalls. And then we'll open it up, as I said, about 1 o'clock for about half an hour of some Q&A. I'll try to reserve plenty of time so you can ask your questions. So in prior presentations, I've often found it's helpful if we get through the materials and then can certainly entertain whatever questions you may have. So a little bit about my background. I'm a corporate attorney with K&L Gates. My focus has been primarily on emerging growth and venture capital. I joined the firm about 14 years ago. I work out of our San Francisco office, and a lot of the clients I've worked with are based either here in San Francisco, California, throughout the U.S., and also internationally as well. I really enjoy working with and helping entrepreneurs and startup adventures that they embark on. It's exciting to be a small piece of what these startups are doing with amazing innovation, amazing creativity, what technologies are being developed to service needs that are out there. So it's been great to be a part of that, and I really enjoy doing that. So let me ask the audience a bit. I'm going to launch a little poll here. Just a couple quick questions, if you don't mind taking a few minutes to answer, just to give me a sense of where everyone's located and then what your background is. So if you could take a minute to answer the questions, that would be great. So we'll give it another 15 to 20 seconds or so. Okay. I think we've got a decent amount of people that have participated. Okay, so it looks like about 31% are in the Bay Area. We've got about 40-some% elsewhere in the US, and some in Asia, 4%, 10% in Europe. So it's pretty scattered throughout, mostly the US, and then we've got some in Asia and in Europe, and then a few in Africa as well. That's great. Well, welcome everyone. And then with regard to background, so it looks like about 55% is the majority of first-time entrepreneurs. Okay, that's great. We've got about 22% or so that are serial entrepreneurs. That's wonderful too. And about 20% are in an early stage company. Great. Well, I think the topics that we'll be talking about today will really be well suited for you, because it will cover some of the things that you can anticipate when you're preparing your company for a VC financing. So let's move on now and talk about sort of the first sort of key issue that comes up when you're thinking about your startup and getting it ready to go out and raise financing. It's really going to be setting up the entity, right? So when you set up the entity, you got a couple of choices to make. What kind of entity should you set up, and where should you set that entity up? And I'll talk about some of the pros and cons. The vast majority of entities that I see being set up are set up in Delaware, and they're set up as a corporation, and for a number of reasons. So the corporate format is one that is well suited to taking on investments, going out and raising financing. It's a format that a lot of investors like much better than other types of entities, such as an LLC or a partnership. And in fact, oftentimes many investors will insist that they will only invest in a corporation. And they also like the preferred jurisdiction of Delaware, which I'll mention in a moment. So, one of the reasons why you might want to form a corporation, obviously tax issues, liability, you have a protective shield, liability shield, if you're in a corporate form versus some other forms. And I'll talk a little bit about LLCs and partnerships, but we don't see those very often at all for venture capital type financing. The ownership structure and equity grants in a corporation are very well understood by investors. They can be set up a little bit easier than they can in some other types of entity forms. The capital raising requirements, as I mentioned, a lot of investors specifically want to invest in a corporation versus an LLC or a partnership. And with regard to the regulatory framework, the corporate form has been around in the U.S. for many, many years. And so it's really, it has a long history, and the statutes, especially in Delaware, has a long history. So it gets reviewed and revised. So you've got a really good set of corporate laws that govern the corporate form, which is another reason that oftentimes people enjoy the corporate form versus having some other type of format. Sorry, I'm just checking the chats here. So it looks like a few people are having a hard time hearing me. So I'll try to speak a little bit louder, but hopefully that helps. So the corporate form, as I mentioned, is definitely preferred by investors. Delaware being sort of the preeminent state in the United States for where you would set up your corporate format. So Delaware, for a number of reasons. One is it has a Secretary of State that's very efficient. It has the ability to go and make your filings sometimes within the same day, sometimes within a couple of hours. They are usually much better and quicker than a lot of the other Secretary of States and other jurisdictions that can take a lot longer to turn around filings. They also have, the Delaware statute is regularly reviewed and updated, and it's generally very well written. It's very well balanced between sort of management and ownership. It is very much favored by investors because it is well respected. The writing is clear. It's generally well balanced, as I mentioned, and so you have a lot of reasons that make it much more preferable to have Delaware as a jurisdiction than some other states. And I mentioned a little bit about LLCs and partnerships. So oftentimes investors don't want to invest in a pass-through entity. So an LLC is a pass-through entity, and without going into too much detail, that means essentially the LLC itself does not pay any tax. It passes all of the tax through down to the individual owners of the LLC. And in some cases, that can be a great way to structure your business. But if you want to go out and raise capital, and especially you're going to be going and getting VC capital, they oftentimes do not want to have a pass-through entity. They have a particular structure set up with funds and don't want to have the ability, or don't want to have the situation where then the taxable income of the entity is passed through to the individual members. So oftentimes that's basically a deal breaker. They won't invest in something that's not a corporation. Okay, so let's talk now a little bit about founder and early employee documentation. So you've set up your corporation, you've set it up in Delaware. It's a C corporation. That's great. So now you need to start thinking about making sure you're documenting things appropriately. And the very first few sets of documents, other than the corporate formation documents, will be essentially as a founder, your ownership in the company. And as you start to take on some early employees or maybe some early consultants, you want to make sure you've got good documentation for that as well. Definitely good documentation is key. And it's something that will come up down the road if it's not done properly when you go out to the investors and they start to look at your company and they start their diligence review. If things aren't done properly and buttoned up appropriately, then that raises all sorts of red flags. Some of those things can be cleaned up. Some of them may be serious enough where the investor may decide not to invest based on problems that they're seeing during diligence. Oftentimes, a lot of those can get worked out, but early documentation is key. Building a habit to ensure you have the proper documentation will be invaluable to help position your company for VC financing. I'll explain all that why that's so important a little bit later on. So documentation, what are we talking about? We're talking about making sure you have good assignment of any IP. So as a founder, if you're setting up the company and you've got the idea for the technology, then you want to make sure that as it relates to the business, that it's being assigned to the company. So the company owns the IP that is being developed or has been created, as well as anyone else who's contributing. So if you go out and get early consultants, advisors, employees, and they're helping you develop the technology, you want to make sure you have the appropriate agreements in place that essentially has the IP that they're developing, where it relates to the company, assigned over to the company. And a lot of that is state driven. So you want to make sure that if you're located in, for example, California has a very specific labor code section that says basically if you develop something on your own time, using your own resources, not relating to the business, then that's yours. But if you develop it using the company resources, company money using company information and it relates to the company's business, then it should be considered the company's asset. But without a clear document to explain all that and make sure it's governed properly, it can sometimes lead to disputes early on where you have someone that joined early, helped you develop some key technology, and then later ended up leaving, didn't sign the appropriate documentation, and now you've got a question about who really owns the technology that is so critical to our company. So making sure you lock those down early on is really key. The second issue that we talk about, or we often look for and help our clients with, is proper documentation for the securities that are issued early on. So as a founder, you get shares in your company. If you bring on early folks, employees, consultants, and you're going to give them some shares, you're going to give them options, making sure that that is all done in a way where you've built into those issuances motivation, incentives to make sure those folks stick around for the long term. So how do you do that? Basically, you have a vesting schedule, and typically the vesting schedule is over a 4-year period, so that if they were to leave before their shares are vested or their options are vested, then they don't get the benefit of having those, or the company can repurchase those. And it's treated a little bit differently for shares and options. I'll talk about shares for a moment. If you give someone shares initially, including the founders, you have them vest over 4 years with oftentimes what we refer to as a 1-year cliff. So nothing vests for the first year until the first year of service is completed, and then 25% vests, and then the remaining 75% vests over time over the remaining 3 years. So let's say you're there for 6 months, and then someone decides, you bring someone in, they start contributing, they leave within 6 months. They haven't completed a full year yet. So essentially, the way the documentation would be set up is the company would then have the right to buy back those unvested shares at the same price that they paid for. So that gives the company the ability to make sure that if someone's going to leave and it's early stage, they've either developed something or they haven't quite developed it, they haven't done what they said they're going to do, but you've given them shares and now they're going to walk, that the company can repurchase those shares back. So what you don't want to have happen is someone who gets a bunch of shares, they're there for 3 or 4 or 5 months, they decide, no, I'm going to go on to my next deal. They leave with some ownership in the company, but they're not contributing to the company's success anymore. So it becomes, as we call, sort of dead equity. They're not going to be helpful to the company going forward, but they're still sitting on your cap table and you got to deal with them. So having those sort of mechanisms incentivizes people to stick around. It also is something that the VC, the investors are going to be looking for too. They want to make sure that everyone's incentivized. So oftentimes, if you don't have those built in your documentation initially, investors may ask you to go back and amend it to build that sort of those vesting conditions into the securities. Transfer restrictions is another issue that's important. So making sure that you've got appropriate restrictions on people being able to transfer shares. I mean, we have obviously the securities laws that need to be complied with, but you also want to make sure from a company standpoint, you understand and you have some sort of restriction on the transfers that might take place. So, do you want to have someone, for example, be able to transfer shares, without getting board approval, or, to set up a trust or inheritance or things like that? That's typically not a problem. But what you don't want to have is a situation where you bring in an investor, they invest, and then they subsequently want to, sell their investment to somebody else. And assuming they can comply with the securities laws, you may not want to have a new investor that you don't know. It could be an investor that's doing something that's competing with your company, and you wouldn't want to have them as part of your company ownership. So there's those issues that come up. I mean, those can be in shareholder agreements, they can be in bylaw provisions, they can be in stock purchase agreements, but you want to be thinking about that so you have appropriate restrictions in place so that people don't have the ability to transfer their shares without the company having some sort of say-so as to who gets the shares. Okay, so let's move on and talk about financing options. And I know we've got a few questions. So at the end, I'll certainly go through the chat and make sure I try to touch on all these questions too. So I appreciate you setting them up in the chat. Okay, so for financing options, you've got a bunch of different choices here, and I'm sure you may have heard about some of these or not. I'll run through a few of them so you have some familiarity with them. But oftentimes when you start out in its early stage, the company will raise money by either doing convertible note or doing some sort of convertible equity financing. And I'll touch on those. And then obviously, as you get a little bit more advanced down that road, at some point you'll do an equity round, or priced equity round, as we call it, or a venture round. So I know the presentation's focused on helping you prepare your company for a venture financing. That would be what I'm calling here the venture round. But prior to that, you oftentimes will either raise money by putting in money yourself, but certainly if that's not sufficient, you'll go to what we call friends and family to do very early stage investments. And those oftentimes are set up a little differently. They're set up as either a convertible debt or as convertible equity. So convertible debt, also called bridge notes, is essentially a note. It's a loan. And it's a loan that'll convert based on certain terms into equity at some time in the future. Convertible equity is different. It's got some of the same features. One of the more common instruments you'll see is called a SAFE. It's an acronym for Simple Agreement for Future Equity. And I'll touch on that in a moment. But basically, it gives the investor the right to convert into equity when there's a subsequent financing, qualified financing. And we'll talk about that in a moment. And then, of course, you get to your, equity or venture round, if you will, which is really where the company sells stock. Usually, it's preferred stock. I mean, not very common, although I've certainly seen it, where the company goes out to investors to sell common stock. Not common at all. More often than not, it's really selling preferred stock, and that's really your venture round, if you will, priced equity round. We'll talk more about that. Okay. So with convertible securities, it's a security that, by its name, you can understand it converts into some sort of security in the company, shares in the company. So basically, it'll convert to future equity at some sort of negotiated discount once there's a subsequent financing, what I refer to as a qualified financing. And that's defined in the agreement that you'll sign or that you have, the company will prepare. So when that qualified financing occurs, this convertible security will convert into shares that are being sold at that qualified financing, subsequent financing. So some of the benefits of doing a convertible note or convertible securities are it avoids having to go out and get a valuation for the company. It's also a lot easier to document and less expensive than doing a venture round. So venture rounds can be expensive depending on who the investor is, investors are, who their counsel is or are. I mean, that can easily be anywhere from 25,000 to 50,000, 60,000 plus in a venture round. So it's expensive. So at very early stages, oftentimes it's easier and a lot less costly for the company to go out and do a convertible security. Gets money in the door, gets the company the ability to have some cash to move the process forward, further develop the technology of the company to a point where you've got maybe a prototype, where you've got something you can demonstrate to an investor like a venture capitalist, who can then appreciate the fact that not only do you have an idea, but you've actually now got proof of concept, or you've got some sort of prototype, or you've actually developed it to the point where you've got some initial users or customers, sales that demonstrates that it's viable. So using that convertible security as a tool to get you there initially can be really helpful. Downsides, well, at least for convertible notes, it's a note, so it's debt. It's going to be on your financials. It will have a maturity date. So at some point it needs to get repaid. Although oftentimes with convertible notes involving startups, the investors that are loaning the money don't really want to get paid back. They really want to convert at the next, when you do your subsequent financing or qualified financing, because they obviously invested not because they want an interest on their loan. They're really looking to be able to get a return once the company does well and has an exit. But nevertheless, it does have a maturity date, so you need to be aware of that. And they are actually considered creditors since they're lenders, so they jump up at the very top of the stack of people that would get paid off if there's some sort of liquidation, right? Because creditors get paid before owners, before equity holders. So that's another feature that sometimes can be for the company can be a downside. For the investor, oftentimes that puts them in a better standing than if they just invested and got stock. Some other features of convertible securities, maturity date I talked about. When it matures, it could be anywhere from a year to 3 years. It could be longer or shorter than that, but that sort of seems to be the general time frame I oftentimes see. It's enough of a runway. It gives you enough time to be able to get further down the road and hopefully get to that point where you can raise your qualified financing. Interest rates generally fairly low, because again, they're not these lenders, the investors doing a convertible security like a convertible note are not really looking to make a lot of money on their interest, on the principal. Conversion terms. So how does it convert? What does it convert into? How can the note be amended? If you go out and do a convertible note financing with a whole bunch of investors that are all going to be loaning money pursuant to a convertible note, then one feature you may want to be considering or thinking about is having the ability to amend the notes if you get a majority of the note holders to agree to amend it. Because if you got 30 or 40 notes out there, if you don't have these kind of amendment terms, you actually have to go out to every single person to amend it. So oftentimes, you'll put a maturity date out there that's, let's say, a year. You get to the 9-month mark and you realize, shoot, I need another 6 months. So much easier to amend if you've got these sort of provisions. And those are really, at least for the maturity and interest rate, talking about convertible notes and not safes. Conversion terms we talked about. There can be mandatory conversion at a discount of the price paid in the next qualified financing. That's not unreasonable or not uncommon. We do see those quite often. It just has to be a reasonable amount. So we typically see anywhere from 20 to 25% as being sort of reasonable. Anything above that, the later investors are going to squawk and not like the fact that the earlier investors are getting such a discount. Because think about it, as if you're coming in as a later investor and you're putting in, let's say, $1 a share, but because of the convertible notes that have previously been issued, they're coming in and they can actually convert at 50 cents a share or 20 cents a share. That's a huge discount. So they're going to come in and grab a lot of the stock, and the subsequent investors who are paying full price, the $1 a share, are not going to be too happy about that. There can be, cap on how much can be converted, conversion upon a change of control or sale of the company, that it'll convert upon that type of event. Or it could have optional maturity or conversion, so that once you get to the maturity date of the note holder can convert it, or the company could convert it. These are all negotiable terms, but important to be thinking about. Okay, so let me back up for one second, because I didn't talk as much about safes. So safes also very similar. It's not debt, so it doesn't have a maturity date, doesn't have, not principal and interest, but essentially it's the ability to buy or convert rather into stock that's being sold at a qualified financing. And you see oftentimes Y Combinator actually created the safe instrument back in about 2013. It gained, some traction initially in Silicon Valley, and then it's been spreading ever since then. Much more popular now, very common in sort of the Silicon Valley, San Francisco areas, West Coast, East Coast is very familiar with it and use it as well. And it's also gained some traction overseas. So nowadays, a lot of early startups are looking to the safe because it's very easy to put in place, very inexpensive, don't have a lot of legal fees, don't have a lot of additional work that needs to get done to have a safe and go out and raise some significant money using a safe. So all good ways to be thinking about setting the company up to be able to go out and then get your venture capital financing. So some foundational basics about valuation and dilution. I'll touch on a few things. Pre-money valuation, value the company before the next round of investment. So it's before the investment goes in, what the value is. Post-money, it's when the money has gone in, it's the value of the company after the round of investment. Issued and outstanding basis, what that means is if you're looking at the cap table, it's looking at all of the stock that's issued and outstanding. And so you would not look at options that have been granted. You wouldn't look at other types of convertible securities that could convert into stock. All you're looking at is what's currently issued and outstanding as stock. The other term that's important to know is fully diluted or fully diluted basis. And that is different than issued and outstanding because you're looking at the cap table and now you're taking into consideration not only all the stock that's issued and outstanding, you're also looking at securities that can be converted to stock. So you're looking at convertible notes, you're looking at safes, you're looking at warrants, anything that could be a convertible security that'll convert it to stock. And it's important to look at both of those because you want to be looking at the ownership of the company, the cap table, not only as it currently is on an issued and outstanding basis, but when you're looking at raising financing and you're getting ready for your first price equity round, it's important to understand what the fully diluted basis is going to be, pre-investment, but also post-investment. So you can see the difference in the impact of taking this new investment on will have on the current ownership. Sorry, one quick question. Yes, we are recording this and it can certainly be available afterwards in case you don't get a chance to see the full presentation. Okay, so I'm going to run through this. I want to make sure we get to plenty of time for the rest of the presentation and Q&A. But so just a couple of quick samples. Let's assume we have a company that has a pre-money valuation of 10 million and that there are 10,000 shares that have been issued to 3 founders. So essentially everyone has a 1/3 interest in the company, the 3 founders. So now we talk about an investment of $3 million at $1 a share. And the pre-money valuation, as we talked about, is 10 million, right? What's the value of the company before the investment? The post-money valuation is going to be $13 million. And you can calculate out what the price per share, it's $1 a share. So the founders, each founder will have, once the investment is made, they'll have approximately 25% of the company, whereas before they had about 33%. Post-closing with the $3 million investment at $1 a share, their ownership will be diluted down to approximately 7-8%. So they'll go from 33 to about 25%. That's important to keep your eye on as you start to prepare for this too. And one of the fundamental tools you'll use to sort of track that and calculate that is a pro forma cap table, which essentially is your capitalization table, which shows all of the shares issued and outstanding, as well as your options and anything that's convertible. And then you'll go through and calculate out, based upon what this new potential investment is, what impact that's going to have on the current ownership. And so that's important to keep your eye on because depending on how the negotiations go and how much of the company you want to sell, you can then calculate out and figure out what kind of a dilutive impact that's going to have on your ownership. And I can tell you from experience that, sometimes people haven't done their homework, don't understand that very well. They go in and negotiate a term sheet with an investor. And when the deal closes and they then figure out what the actual ownership is post-closing, they're a little surprised that they have so much less than what they thought they were going to have. So part of what we'll get to in preparing for a VC financing is making sure you go through that exercise of understanding current ownership, running some projections so you can figure out what the ownership may be with, once the investment closes. Okay, so I think I've got one other example to go through. Okay, so let's talk about another example. This one's an example using convertible securities. So assume that there's a 450,000 convertible security that has a 25% discount. And what that means is basically when you go to convert it, if the qualified financing that it's converting into at the stock's being sold at $1 a share, they get a 25% discount off of that $1 a share. So essentially they're going to be able to buy their stock for 75 cents a share. So if they're investing 450,000 in a convertible note with a 25% discount, they'll end up getting 600,000 shares when they convert at the next financing, assuming the financing is $1 a share. So there's all sorts of, I talk about a circular math issue. I'm not going to really address it now. I'm happy to talk about it offline, but essentially I wanted to focus you in on the fact that when you are going out and raising financing using a convertible security, whether it's a convertible note or whether it's a safe, you also want to be thinking about, how discounts and valuation caps are going to impact the cap table once they convert at a qualified financing. The next example below that is same amount of investment, 450,000 convertible security, but here we've got a $5 million cap, valuation cap. So if you use that, if you apply that, essentially that means that they're going to be able to get their stock for 50% off of what the sale price will be at this qualified financing. So they're essentially going to get it for 50 cents. So their $450,000 investment ends up getting them 900,000 shares. Whereas if they were just a regular investor in this financing that we're using for illustration, where the investor is putting in, 3 million for $1 a share, they would only be getting 450,000 shares, right, at $1 a share. But because they negotiated and got this valuation cap, when you run the numbers and do the calculation, they end up getting twice what the investor at the qualified financing is going to be getting. Okay, so just a couple of examples, but I can't emphasize how important it is to run through these as you're starting to prepare for a priced equity round or venture round, if you will. And I'll touch a little bit more on that as well. Just check our time. I think we're doing well on time. So let's talk a little bit about the overview of what a venture financing is and what you should be thinking about as you're starting to position your company for a VC round. I mean, obviously, one of the most important things, and it's really sort of the very first starting point, right, is having a credible business plan, having milestones, and then being able to explain that in a very concise way to an investor. And I don't know if you've been to any sort of pitches or if you've ever pitched before. I know we've got some serial entrepreneurs, so they're probably fully aware of how important it is to really perfect your pitch. And really, it's being able to go in and tell a really good story, an accurate story, but a compelling story why that investor should invest in your company. So business plans may or may not be written in the very early stages. It's oftentimes sort of a slide deck, if you will. I mean, the old days, a business plan was a very sort of formulaic, it was a very sort of standardized approach to what you'd have. They could be 30, 40 pages. Investors, especially VCs, they don't have time to read through that. They want something short and concise. So now we oftentimes will just refer to a sort of an investor's deck. And it's usually short, it's fairly concise, but it gives them all of the basic elements of your business plan that they're going to want to be able to see and assess to know, okay, yeah, this looks like a good business. Let's have a further dialogue now and go forward to see if this might be a company we want to invest in. But you have to be able to articulate all the things that are important in your business plan. So your market, what's your go-to market? What's your time frame? Are there any impediments to getting to market? What are the capital requirements to get your product out, your technology out? And then you also need to understand what the risks are to your business plan. Is there a technology risk? Is there some sort of risk of being able to execute? Is there a market risk, regulatory risk? Those are important because, believe it or not, I mean, obviously the VCs, if they're in your industry or if they know your industry, they're going to know those as well. And if you don't anticipate those, and if there is a particular risk, and if you haven't articulated a challenge, a way to get around that challenge, they'll see that as someone that's not really as prepared as they could be. So make sure you do understand and can go through all of those risks. I always like to tell people, if you're not a good storyteller, then practice and practice and practice until you can really tell a good story. I mean, I've been on a bunch of judging panels and listened to a whole bunch of pitches, and what oftentimes keeps my interest and gets me really engaged in what the speaker is saying is they're just a really good storyteller. So I want to listen because of the way they're talking. They have a nice cadence and rhythm. They use interesting words. They're explaining things in a way that I can understand. It's no different than, anytime you go and you hear someone speaking, everyone can kind of tell between someone who's really energetic, passionate, able to deliver a really good message that's interesting, versus someone who is maybe not that interesting to listen to. They don't have a good presence. That storytelling aspect is really important. Okay, enough on that. Running a systematic process, basically making sure that you have enough capital from your earlier rounds, but that you know what you're asking for, and usually it means actually asking for a little bit more than you might think you need, because oftentimes we'll shortcut and say, well, okay, I only need $1 million, or I only need 2 million. But when you really get down into the details, you really actually need a little bit more, because you need to make sure you've got enough runway to build out your technology, get to market, whatever the next phase of your startup is. And usually things oftentimes cost more than you think they're going to cost. So building in a little cushion is definitely recommended. Connecting with the right investors, can't emphasize that enough. If you've got so your company is focused on health tech, and you've got some sort of device that's going to be the latest and greatest in detecting something, or handling some issue within the healthcare need, and you go out and pitch to a company that's really focused on investor that's focused on renewables, you're just not going to get that kind of traction. It doesn't say you won't. There aren't deals that are made where investors that aren't really in that particular space invest in the technology outside of their typical approach. But more often than not, they sort of stay in their lane because that's the lane they know, and they've done a ton of research, and they really know the area, they know the market, they know the competitors. So to venture into something that they really haven't studied as much, some do, but oftentimes it's better to really make sure you're connecting with the right investors. Understand your ideal term sheet. So this is really important too, and lots of stories about how deals go, but I've oftentimes come into a deal when the founders already negotiated a term sheet, didn't have the experience, hadn't done one before. They ended up agreeing to a whole bunch of terms that we may have been able to negotiate out, or may have been able to negotiate different terms, and now they're kind of stuck. Now, term sheets are by nature in this space oftentimes not binding, except maybe a few provisions like confidentiality. There could be no shop or exclusivity that is binding for a certain period of time, but essentially the other terms are oftentimes non-binding. And so that's good, because it means you're not bound to that very short 1 or 2 page agreement. But it's also something to be aware of. It's a double-edged sword, because you don't want to negotiate a term sheet and sign it with a VC if you then later on decide, well, shoot, I should have asked for this, or should have asked for that. Now I want to change it. It's true that that provision probably is not binding in the term sheet, but you've already sort of established, the terms of the deal. So if you then go back and want to change it, it can potentially, cause ruffle feathers with the investor, and that's never a good thing to do. Preparing for thorough diligence. Let me back up for a second. So term sheets oftentimes depends. I mean, if you're a company or if you're a serial entrepreneur, you're very comfortable with the term sheet, you've negotiated a whole bunch of them in the past, you could certainly prepare a draft and go and talk to your potential investors. Oftentimes, you'll see the investor drafting the term sheet, and that's when it's really important to make sure you understand all the terms that are in your term sheet. Because, keep in mind, if this is a term sheet they've used, or these terms are terms that they've used in many investments over the years, they're going to know it exceptionally well. And if you don't know the terms and you don't understand the language as well, you're at a disadvantage, because it's like playing poker. If you like to play poker occasionally, you're a decent player, and then you sit down at a table with a professional player. Your odds of winning against that person are going to go down significantly. So don't put yourself in a position where you've got a whole bunch of, you got a very sophisticated investor, you're looking at their term sheet and you don't really understand it. So we'll come back to how to make sure that doesn't happen. Essentially, the short answer is get good advice, do your diligence, do your homework, read up on term sheets, understand them, and then make sure you've got good counsel to help you with that. Prepare for thorough diligence. You're going to go through a lot more diligence in a VC round or venture round than you will if it was a convertible security round, like a SAFE or a convertible note. Oftentimes, the diligence is a much deeper dive. It's going to be looking at all of your corporate records. It's going to be looking at all of your, if you have customers, your customer agreements, other agreements, employment agreements. It's basically turning over all the different stones in the courtyard and making sure that everything's covered. And so you want to make sure you're prepared for that. And I'll mention that it's a good practice to kind of go through that exercise before you get to the point where you're even talking to an investor. Have good corporate hygiene, kind of goes hand in hand with diligence. Make sure from the get-go your documents are in good shape. They're complete, they're dated, they're signed. You've got the right documents for the right occasion. You've sort of set the habit early on to make sure you've got all that going forward, and you've got a nice organized way of keeping them all together so that you don't run into a scenario where suddenly you've got an investor, you're going to be able to sign a term sheet in a few days and you don't know where any of your documents are. They're all over the place. So, and I'll explain why that's so important. It seems like it's, okay, yeah, we'll get to it when we get to it, but there are some good reasons for why it makes sense to front load a lot of that work. And then be prepared for cleanup. So if you have not done a good job of organizing all your documents and getting everything in place, you can anticipate during the diligence process, investor or their counsel will raise questions about, well, how come you don't have an agreement, an IP assignment agreement for this employee? Aren't they the one, they're listed as an engineer, they developed some of the software, but we can't find where they've signed over the IP they developed to the company. You could have other issues where your cap table isn't accurate, so you've got someone that shows less stock than they actually have or more stock than they really have. All sorts of issues can come up. And those oftentimes, many of them can get cleaned up during that process. The problem though is then you're running a parallel track of having to clean stuff up while you're also negotiating and moving forward on your investment deal. And it can be a bit of a time drag or time suck, because now you've got to take focus on internally at the company, but also your attorneys now need to focus on cleaning up stuff to then be able to answer questions or address diligence issues that come up with investors counsel. And we'll talk a little bit about how to minimize that. Okay. A little bit more on overview of financing. So we talked about understanding your ideal term sheet. And what does that mean? I mean, what are some of the things that you should be thinking about as you get to the point in time when you're going to be negotiating a term sheet? Well, first and foremost, how much of the company are you going to sell? What are there going to be dividends? What are the liquidation preferences? And what that really means is when an investor invests and buys preferred stock, the terms of that deal will have language in them that says basically if there's an exit and there are proceeds from that exit, that there will be some liquidation, as we call it, a liquidation waterfall or a waterfall, where those early investors that are buying preferred stock, let's say it's a Series C or Series A, that they're going to get paid out first before anyone else gets anything. Not including creditors, as we mentioned, because creditors get paid first. Companies got to pay its liabilities, and then what's left can go to the owners. But within the ranks of the owners, there are differences in preferences, liquidation preferences, as to who gets paid first. And that can come in a lot of different flavors. So oftentimes you'll see a one times liquidation preference, meaning that the investor gets one times their investment. They get their investment back before anyone else gets to share any proceeds. We've seen other multiples as well, but that's oftentimes a pretty common multiple. Voting rights. So who gets what voting rights? Do the preferred stock vote separately? Do they vote with the common? Are there certain types of actions the company may want to take that require the vote of a certain share, certain class of shares? So for example, oftentimes when venture capitalists are investing in a deal, they're going to want to protect their investment. And one of the ways they can do that is to put into the documents, it's usually in the charter, the certificate of incorporation, these protective provisions. And those provisions protect their investment by ensuring that the company goes out and gets their approval or their consent before certain actions are taken, like selling the company. Oftentimes it's, you want to go out and raise more money and you want to create a new class of shares that'll have a more senior rank than the shares that this other investor got. Before you do that, you need to go back to the investors that bought the preferred stock and get their consent. So those are called protective provisions. And oftentimes you'll see a list of the things that the investors are concerned about that'll be covered in there. But it's important to know what those are, and it's important to understand that the more protective provisions that go into your charter or your documents, the less flexibility the company's going to have when it comes time to take those sorts of actions. Then you got to go out and talk to your investors. Optional and mandatory conversion. So preferred stock is also a convertible security because it will convert or can convert into common stock at a point in time. Oftentimes that point in time is when there's a liquidity event, when there's going to be a sale of the company, a merger, it's going to go public or something where it would make sense potentially to convert the preferred stock into common stock. And that part of that goes back to understanding what the liquidation preference is and how it's being treated to determine whether or not the preferred stock should convert into common or not. But anyway, there are optional and mandatory conversion rights. Important to understand what those are when you're negotiating term sheet. Do you want the preferred stockholders to be able to convert at any time, convert under certain circumstances? Should everyone be converted when a certain event occurs? Other considerations or issues that come up are anti-dilution protection. So if an early investor, let's say if the VC investor comes into the company, buys stock, they get preferred Series A, will they have, or are they going to negotiate for some sort of anti-dilution protection so that if there is a subsequent round, will they be able to invest in the subsequent round, maintain the same percentage they currently have? If there's a down round where the price goes down, is there some sort of protection that covers the fact that they paid more for their security than this subsequent round, which is now being sold at a lower price? So those are sort of the issues that oftentimes can come up when you're talking about anti-dilution protection. And it's important to understand that because that's going to impact the company and the cap table, depending on how those are negotiated. Vesting for founders. Important to understand, I mentioned earlier on when we first started, but the company has obviously an interest in making sure that its employees and consultants are vested to stay, incentivized to stay with the company, right? One of the reasons why you have vesting for shares or options they're going to get. Equally important for founders, and especially important for investors like the VC, because they want to know that the founders are typically the brainchild of the business. So they've got the idea or the technology or the ability to get this company going and to start seeing it through the various stages and milestones. So they don't want to be in a situation where they invest money and then suddenly the founder takes off and that founder just happened to be the tech guru for the company, and now everyone's scrambling to try to replace that person, and you may be able to or you may not be able to. So making sure that you've got the founder stock restricted and subject to vesting is going to be important as well. And again, it's the typical, what I oftentimes see is 4-year vesting, 1-year cliff. Applies to founders equally as it does to employees and oftentimes consultants. Documentation we talked about. There'll be the appropriate investment documents for the preferred equity round or the venture round. Attorney's fees, important to talk about that too up front, because oftentimes the VC firms they're looking to invest, the lead investor, there'll oftentimes be a lead investor. So not always the one that writes the biggest check, but oftentimes is the one that writes the biggest check. But the lead investor will oftentimes want to have their attorney's fees paid by the company. And it's usually up to a certain cap. So frequently we'll see a cap anywhere from, for an early stage, like a Series C or even a Series A, anywhere from 25,000 to 50,000, generally in that range. So that means that the company is responsible for paying its attorney's fees and the fees of the lead investor. So, it can be a significant amount, and you want to be careful on how you negotiate that. If you're raising a smaller round, maybe you negotiate more on the fees depending on who the investor is. But anyway, that can be negotiated oftentimes. There's maybe a little bit of wiggle room, but it's something to be aware of. No shop and confidentiality. provisions. Those are the two provisions oftentimes that you will see in a term sheet that are binding. So the confidentiality is important because you don't want to be disclosing information that then someone could take and disclose if it's sensitive. The no shop oftentimes is basically the company telling the investor, we're not going to go and start shopping the investment around to someone else. If you've shown interest and you're willing to sign a term sheet, we'll give you 30 days, 60 days to close a deal, and we're not going to go talk to anyone else. Sometimes you'll see them in term sheets, sometimes you don't. It's really, that is definitely subject to negotiation, and some investors require it, some don't, but something to be aware of. Okay, so we've got a little less than 10 minutes. I got a few more slides to cover, and then I can start. If we end early, we can certainly open it up for Q&A a little bit early. So the diligence process, if you haven't experienced a VC type financing, here's what I would recommend. It's before you ever even go talk to a VC investor, where when you're serious enough about starting and getting ready for your round, get a hold of some of the investment documents that you typically will see in a VC investment, and read them and study them and understand them. And if you're not sure what they mean, go do some research to really get as familiar as you possibly can with those documents, so that when it comes time to actually sit down and negotiate a term sheet, you've got all that background information that'll be helpful. It'll also be immensely helpful to you when you're working with your legal team, because it'll mean you'll be able to work much more efficiently and effectively, because you'll understand what those agreements are asking for. If it's diligence related, you'll understand some of the terms. So it'll be much easier communications with your attorneys, because they'll be asking information, and if you've already read it and understand it, you'll know how to answer, and you'll be able to work much more efficiently, and it'll result in most likely a lot less in legal fees. There are some great samples out there. So on the screen, the slide, you can see NVCA, National Venture Capital Association. It's probably the leading organization for venture capital financings. I don't remember exactly when it was created, but it's been around for a long time. They've got a lot of information on their website, but one of the really nice things they have, and they've had for quite a long time, are model documents. And these model documents are used over and over and over again in a lot of venture capital financings. So if you start with that as your sort of research project or homework project, call it what you will, and study those, that will probably get you, to the point where you'll be able to understand most of what is given to you when you get that first draft of your, first venture round. Because chances are, and I'd be willing to bet some money on that, the documents you receive are going to be either based on very closely the NVCA forms, or, maybe not verbatim, but will be close enough where you've read it, understood it. You'll have a much better handle and an advantage going forward on positioning your company for a VC financing. There's another site you can go to called Series Seed. This was developed especially for smaller, sort of Series Seed financings. The documentation is a little bit lighter. It's a little bit shorter. Doesn't have as many of the provisions that you'll see in the NVCA forms. Also a really good set, and a lot of companies will use that. But if you start with the NVCA forms, they're also annotated, which means as you go through the forms, they've got footnotes and explain, why an investor might want a certain provision this way versus another way, and some options. And so helpful for obviously investors, but super helpful for founders and entrepreneurs as well. So we talked about reviewing those documents. And then what I would do is I would actually take or get a hold of a diligence request list. There are some standard lists out there. I mean, oftentimes the lists are asking for many of the same things. It's the list that you'll get from the investors' counsel once they're ready to start their diligence review. And it's basically, give me everything that the company has. It's all your corporate records, your financials, tax records sometimes, it's customer agreements, it's all sorts of stuff that needs to be reviewed and assessed to make sure that the investor knows what it's getting when it puts its money in your company. So if you start with that and look at it, understand it, look at what is going to be asked of you, and then take that and start organizing your corporate documents, your company documents, in a way that will allow you to very quickly respond to a request when it comes in, when you actually start your venture round, because you've already gone through the process, you've looked at the list, you kind of know the sort of things that'll be asked, and you've not only understood it, you've also then gone and started to organize your documents that address some of those requests, even to the point of maybe creating a data room that you have internally that nobody sees other than the company, but it's organized in a way that is very easy to then pivot and make some tweaks and minor adjustments to set it up so you could open it up to an investor and its counsel, and then they can very quickly get through the diligence process. Let me make sure I've got a couple more minutes. So always be closing. I mentioned early on in the overview that I'd be talking about, sort of this ABC concept. So background is, ABC was an acronym that one of my mentors had used, and it basically means always be closing. So from day one, your mindset should be closing the transaction. So always be closing. Always think about getting to closing. So whatever you do should always be focused on getting to your closing. So do your homework. Make sure your company records are in really good shape before you go talk to investors. Make sure your cap table is up to date, it's accurate. Run some performas. So that's, your performa is essentially your cap table. And then what you do is you take that and then you start running some scenarios. What would happen if someone invested this amount and bought this number of shares? How does that impact everyone? Understand that, have at least a good sense of that, maybe set up a data room, and do your own diligence on, potential investors. That goes to the point about really knowing your investors. They're going to do a lot of diligence on you. And oftentimes what the new entrepreneur does, the entrepreneur that hasn't been through this process before, is they don't do as much diligence on the investor as they should. So not only should you know the investor, the markets they play in, the kind of investments they've made, but also where are they in their trajectory, sort of in their timeline? Are they sort of at the tail end of their fund? Or are they in the very beginning part of their fund? How much money do they have once they make the investment in your company? Should there be subsequent rounds and you want to have them be able to invest in subsequent rounds? What's their sort of philosophy of investments? Do they oftentimes put enough in the initial investment thinking they're not going to invest anymore? Or do they put money in knowing that they're probably going to be investing in subsequent rounds? All good stuff to be looking at and thinking about before you start working on your VC deal. Create your team. Make sure you've got a good team internally, good team externally, attorneys, other advisors. Set reasonable timelines. Oftentimes you can think about a typical VC round, fairly simple, nothing overly complicated, taking anywhere from 30 to 60 days to close. So you want to make sure you build into that timeline, build into that enough time to be able to complete your deal. Organize and divide tasks to make sure you've got the right people working on the right things so you're not duplicating efforts. And I'm almost out of time here. I think we need to start our Q&A, but talking about common pitfalls. So I'll touch on these very quickly and then we can open up for Q&A. Securities compliance is critical. In the US and oftentimes other countries, you can't sell securities unless it's registered, which is extremely expensive. That means sort of doing an IPO, right? Startups are not going to do that. The only other way to legally sell a security is you have to have an exemption that allows you to sell it without registering. So that's where the private company, the VC investments, the startups, that's where you need to be able to make sure you're complying with all of those security laws federally and on the state level. And it's something your lawyers will do, but it's good to be keeping an eye on and making sure there's good communication between the company and the lawyers with regard to what security issues need to be concerned about and handle. Regulatory issues, if you're in a space that has a particular regulatory issue or regulatory issues like a healthcare product, you need to be aware of those and make sure that you're managing that and complying with those. Not managing cap tables. I've seen all sorts of scenarios where the cap table is not managed, things aren't accurate, then there's a mad rush at the end to fix it. Sometimes you can fix it, sometimes there's issues that come up that you can't fix. It just creates a bit of a nightmare. People can show up with undocumented stakes in the company. They got some documents that they have shares, they're not on the cap table. It can really screw things up. Thinking that there's standard forms, standard terms, it's all boilerplate, right? No, yes, there's language you'll see over and over again, but it really needs a fine eye and experience to make sure it's appropriate for that particular agreement or that particular transaction. Finders, side letters, not getting the right corporate authorization, not getting vesting agreements in place, employment issues. So all of these things can come up. And if you think about them beforehand, going through the process of doing the diligence exercise, understanding the documents, you'll flush out a lot of these issues. And so you won't be surprised as you go through the process when you get to the point of signing a term sheet and then starting the VC round transaction, where you basically minimize or mitigate a chance of this sort of stuff coming up. So I think we're out of time for the presentation. Let me take a pause. Let me run through some of the chat questions, and then make sure that we've got plenty of time to talk about. So I know yes, this is being recorded. We'll certainly provide the link so you can take a look at it at a later point. Okay. So California C-Corp. Yeah, so I mean, California, obviously it's a big state. A lot of companies are, you see a lot of California corps. But again, for the reasons that Delaware is such a preferred location, a lot of investors really want to have their startup be a Delaware corp. Plenty of investments get done with California corps, but oftentimes investors prefer Delaware. So I've seen deals where an investor really likes the company, they want to invest, but they just don't like the California form. So part of the requirement is you've got to convert and move the company, corporation's jurisdiction to Delaware. So that's going to be your biggest issue. If you run across an investor that really wants to invest and you want them to invest and they've got this issue that they don't want to invest in California Corp, you may have to basically what's called redomiciling, changing the jurisdiction from California to Delaware. It can be done depending on when you do it and how early the stages at which you do it. It can be relatively easy versus if you do it at a later stage, we've got a lot of investors, you got a lot of stockholders, assets, things like that. It can be a little bit more complicated. Someone asked about assigning patents to the corporation that they've invented or created. So, okay, so if you're the founder and you're creating this company, and the company you're creating is going to develop this IP, this technology, which is really what you've invented as the inventor, and then you're going to go out and you want that company to be the one that's going to raise financing and go and sell this solution or technology or license it, whatever the case may be, then yes, you do want to assign your patent to the company. And the reason why is investors want to invest in the company that owns the assets that are critical to the business, right? So if that is a critical patent, that IP is critical to the company's business, the investor is going to want to make sure that it's assigned and owned by the company. So I mean, think about it this way. If you were the investor writing a check for $3 million and the critical technology was owned by someone, it wasn't owned by the company you're investing in, would you have an issue with that? I certainly would. I wouldn't want to put my money into a company that doesn't even own the critical technology that the company is going to supposedly develop and then go out and sell. So yes, definitely want to assign them over. Okay, what would be an example of outstanding stock? Well, the founders. So let's say you formed your company. I gave an example as we were walking through the presentation about some dilutive effects in the cap table. So the example was 3 founders formed a company, and they have a total of 10,000 shares outstanding. So they each have a 1/3 ownership interest. That means each of them own about 333,000 shares. So that's what outstanding means. It's actually outstanding. It's been issued. So the corporation's issued the stock, and it's outstanding. It's being held by somebody, whether it's an individual or entity that's being held by them. That's what outstanding means. Okay, so pro forma. Why is pro forma often used before cap table? Are there other types of cap tables? Well, a pro forma really is it is a type of cap table. I mean, it's showing you a snapshot of the capitalization of the company, but the purpose of the pro forma is so that you can look at the current capitalization and then have somewhere in that pro forma where it shows you what the potential impact will be once you take on a new investment. So it's got a sort of projections, right? It shows you the projection of if I took a $3 million investment at $1 a share from an investor, what's going to happen to the shares that I as a founder own, or my other co-founders, or the other people that have invested earlier on in the company? It's going to run those calculations out and show what everyone will end up owning. So you'll be looking at what the current ownership is now, plus what the current ownership will be once that investment closes. And it's important to look at that because you want to know ultimately, how much am I as a founder going to get diluted? If you're an investor that invested in an earlier round, you may want to know because, if you're going to get diluted significantly, you may want to invest in this new round as well so you can maintain your ownership percentage. Well, the only real way to see that effectively is by looking at a spreadsheet that shows you those projections. And that's why, we call it a pro forma, used to sort of assess what's going to happen with regard to the investment. There's a question about safes and whether or not the valuation cap assigned to a safe be used again by a later VC. I don't quite understand the question. Once you have a safe, whatever those terms of the safe are going to be, those will govern, when you get to a point in time when that safe converts at a qualified financing. So you would look back to those terms. And then when you run your pro forma, because that would also be part of your pro forma, you'd put the safe holder on the spreadsheet. You'd calculate out whether they have a discount, whether there's a valuation cap, and use that information to calculate out what they're going to get when they convert. And that's going to be essentially what will happen when that safe converts into shares. Now, if you want to make changes to that, then obviously you'd have to go back and amend the safe. So maybe I didn't quite understand the question. So happy to, if you ask it again, or certainly can talk to you offline if you want to send me some information on that. Does the cap relate to pre-money valuation? So the cap, so I think you're asking about the pro forma cap table. So yeah, so the pro forma, it should show basically what the pre-money valuation is, as well as the post-money valuation. And those will be fields within the pro forma spreadsheet, because you're going to need those fields, as well as what the price per share is going to be, what the total number of issued and outstanding shares are prior to the investment, and then obviously post-investment. You'll need all those data points to be able to calculate out and project out what the company's cap table will look like after the investment closes. And let me just add a little bit more to that. So in the examples I gave, we calculated out what the dollar amount would be on the investment based on looking at the pre-money valuation, looking at the total number of shares that are issued and outstanding. So that's oftentimes where you look at the pre-money valuation, but you should see both of that information reflected. Have I worked with a company venture validator? I've heard of them. I haven't personally worked with one, but I've certainly seen references to them, and I know that some people do use those. And what I would tell you is understanding what the investors are looking for, understanding what the metrics are that they're considering. If the venture validator will help you do that and give you some data points that's going to be useful for you, then by all means I would use it. The more data you have, regardless, understanding the source it comes from, as long as it's a reputable source, is going to be helpful for you. I think we talked about who writes the term sheet. So there was a question about recommending any good resources for finding target-specific angels or funds. Well, if you know, so oftentimes the investment community can be small in some cases. So if you have contacts at particular investment funds or VC funds or firms, they oftentimes know other players, even other players in other industries that they're not in. So that can be a good resource for you. There are angel lists and all sorts of organizations that cater to angel investors that you can also get information from and get leads. There's a lot of information on different organizations. You might be able to look at the National Venture Capital Organization, NVCA website as well. And that'll give you some information about different VC firms that are focusing on different things. But there's a lot. I mean, if you Google, you'll be able to find a lot, but you want to be able to narrow it down to a point where you actually have some warm leads versus just some cold leads. Hopefully that was helpful. Yeah, recording will be made available. Let's see. Sorry, I'm just scrolling through some of the questions here. For companies which are in developing countries or commonly named camel startups, is there any additional rules of thumb or recommendations that should be followed? Well, I guess, the biggest issue becomes if you're in another country, looking to where you want to raise financing is going to be critical, right? Because let's say you're in the EU or you're one of the EU countries, or you're in Africa, there are investment funds and VC funds that are looking for investments in those jurisdictions or those areas of the world. And you definitely want to make sure you target those, because there are a lot of VC firms that don't invest in parts of Africa or in the EU. They are focused primarily on the US. There are other VC firms that will invest in a lot of different areas, including overseas. So you really just need to understand where you're looking for financing from. But if I understood your question to mean if you're looking for financing in the US, then yes, you need to understand if that particular investor is going to be comfortable with investing in a foreign company. And some are and some aren't. It does add a layer of complexity during diligence, understanding what are the documents going to be in English, governed by the law here, assuming you're in a developing country, but you're going to be setting up an entity in the US. That might be one way to make it easier for getting investments in the US, because then the investor would be investing in the US entity, not in an entity that's in Africa or Latin America or somewhere else. But if that's not the case, and you're looking for investments in the foreign jurisdiction, then you need to make sure the investor is going to be comfortable with that, because it's laws they may not be comfortable with, not understand. They're going to have to get local counsel in those particular areas. So it does add certainly a layer of complexity. Not surpassable. It just means probably a little bit more research and homework on your end to find the right investors. Okay, so here's a question or comment. VCs put so much into the term sheets. No wonder founders are eagerly looking for non-VC approaches to funding. Okay, VCs may be creating a situation where they're leading. Okay, well, more of a comment than anything else. Yes, I mean, they do put a lot of time into and a lot of provisions in the term sheets. Venture financing can get complicated. So you want to make sure you cover a lot in the term sheet, right? Because you want to have that discussion early on. And some of the language that you'll see in the documents doesn't need to be reflected in the term sheet, but the main principles of the investment should be, the things that we talked about, the liquidation preference, or dividends, are there protective provisions that will be put into place. Those are super critical to understand, and you want to have alignment between the founder, the company, and the investor. You don't want to push any of those off into the definitive agreements, because then you're going to be negotiating those, and that can stall and cause all sorts of problems. And if there isn't a meeting of the minds on some of those core principal terms, the investment's never going to close. So there are more involved than you might think. And yeah, certainly you can look at non-VC type financings. I would encourage anyone who's in a very early stage startup or is not ready for a VC, go and look at those other sources. Even if you may be ready for a VC, you should still consider whether or not maybe you should do a convertible note or a safe financing before you do your next venture round. I mean, it all depends on where you are in the trajectory of the business, what your needs are, whether you have the investors you could quickly assess and gather together to do maybe a convertible note or a safe financing, or do you need the venture capital money, because oftentimes it's smart money, especially if they negotiate a board seat and they're going to be participating. They can be very, very helpful. I mean, they oftentimes bring a tremendous amount of experience and a network that is oftentimes unparalleled as far as being able to pick up the phone and talk to other companies, talk to large companies that might be interested as a customer, other follow-on investments. I mean, there's all sorts of ways where they can be extremely helpful. Here's a question: what besides capital should founders hope to get from VCs? So I think I was just answering that as, besides money, you really want the VC to come to the table to be available to help you as an advisor, right? I mean, oftentimes VC that's investing, they may get a board seat or a board observer seat, but the board meetings that I've been at where we've had VCs on the board, and I've listened to the comments and certainly seen firsthand that they bring a wealth of information. So that's probably one of the biggest value adds that a VC investor brings to the table is the experience, knowledge, how to handle situations. They've been through this multiple times. And so when something, you get thrown a curveball, they oftentimes have seen it, understand it, and can react to it and give you a whole host of, options. Better than oftentimes, if you haven't been through it, you kind of go through the first time, you sort of learn trial by fire, and sometimes you come out unscathed and sometimes you don't. They can help you certainly come out unscathed, or at least, less scathed, if you will. Would VCs insist on having a co-founder if you were a tech founder? Not quite sure I understand that. I mean, if you're founding the company, and you happen to be the technical person that's founding it, and you found the company, or whether you have a co-founder and somebody's sort of the business brains and you're the tech brains, yeah, they certainly, the VCs welcome that, because they want to know that the person that is ultimately going to make the technology successful is the founder who created it, right? So if you're the one who had the brilliant idea and the technology, that you can solve this need, then having that person as a founder can be very helpful. Question about recommendations for platforms or data rooms. There are a lot. I'm hesitating because, if you're a little bit further along and you've got some money to spend on a data room, if you're doing a deal, the venture capital firm or the investors may have, usually the company sets up the data room, and that's the preferred course of action. But you may want to choose a more robust data room. I think Pitney Bowes, Merrill has their Intralinks is another one, and I can certainly send some additional names out. Those are going to be more expensive, but they have a lot of bells and whistles, and they're bigger companies, and they've got all sorts of protections and features that are helpful. But you can also, I oftentimes see companies will set up Dropbox or Box. The caveat I would give is, just make sure it's secure. You want to make sure you're using a data room that's secure, that is going through proper encryption and has good measures internally to make sure they're keeping your data safe. You just don't want to have a situation where you're not using a reputable provider and then something goes wrong and you lose your data, or it gets accessed by people that shouldn't be accessing it. Okay. Another question about what is your opinion of crowdfunding in terms of risks to the corporation? That's a great question. I mean, we've seen a lot more play with crowdfunding these days. There was a change to the Securities Act to allow crowdfunding, which made it a lot easier to do. It's still, it's still a question mark for some investors as to whether or not they like the crowdfunding. That the upside is if you can do it and you do it properly, you can get access to funds, from lots of different investors, and you can, raise funds pretty effectively. The downside, though, is if you're going to use a crowdfunding platform or do crowdfunding, essentially what that means is you basically open it up to, a lot of people that can come and invest in small amounts, oftentimes. So you may get, you may want to raise $1 million. You do a crowdfunding campaign, and you get a whole bunch of people to sign up and put in little bits and pieces here and there to make up the million. So what happens to your cap table? Your cap table now mushrooms and becomes huge, right? Because if you raise $1 million, and let's say each person's putting in, 10,000, 5,000, 20,000, to get to the million mark of what you're looking for, you've now taken on, 10, 20, 30, 50, 100 or more investors. And so now you've got a whole bunch of people on your cap table, a whole bunch of people that have become stockholders. And as the company, the directors, the officers, now you've got to manage all of that. So now you need to figure out, okay, what do I need to go out and get approvals from? Do I need to get their consents? If I don't need to get their consent and I want to do things that I need to send out notices to the stockholders of what I'm doing. Just managing all that data alone, making sure everything's accurate. It can be an administrative burden on the company. And some companies just don't like having that large of a cap table, don't want to deal with very small investors who may not be sophisticated and can potentially be more of a challenge later on because they might ask questions, they may want information, whereas if you're dealing with a very sophisticated, savvy investor, you oftentimes don't have those same sorts of issues. Okay, so question about, can you define or explain exactly what you mean by a data room? Certainly. So a data room essentially is a place where you can go and store virtually, in the cloud, documents. So think of it as a folder that you can put up into the cloud somewhere that you can then give access to people to look at and access, look at, download, upload. But essentially, it's a repository where you can store your documents, and you then can decide, if you set it up, you would decide, who gets access and who can do what with it. So it can be very effective. There's a lot of different companies. If you go to Dropbox.com or Box.com, those are two examples of these virtual folders or virtual data rooms, and you can get a good idea of what that means by going to those places. So we've got about 6 minutes left, and I got about 30 questions to get through. So let me quickly try to go through as many as I can. How to find out where the VC is in their timeline? Yeah, I would ask them. Go on their website. You may see where they are, how many funds they've have. But otherwise, I would certainly, there's no problem with asking them where they are in their timeline. Was told that Florida is also desirable as Delaware for investment. Is that true? No. It may be fine for some investors, maybe local to Florida or that are comfortable with Florida, but the overwhelming majority of investors, and certainly VC investors, are going to want or will desire Delaware over just about any other jurisdiction. Always exceptions, but that's the general rule. What's the smallest company you can be? Didn't quite understand. What is the smallest company you can be to do a venture? I guess a venture financing. There's no size, but what I can tell you is, the venture capitalists, they don't want to come in with small checks, so they're typically not going to be looking at an investment of a couple $100,000 or even 500 or 6 or 7. Usually, they're looking for much larger investments. So there's no exact rule of thumb, but I would say if you're looking to raise more than probably 3 million or so, I would say that might be the sort of the bottom sort of floor of where VC firms are looking at. Again, that's not absolute. It's for general framework. There are some VC funds that are set up specifically to invest in very early stage companies, and they typically might look at an investment that's smaller than 3 million, for example. Okay, so someone said their co-founder looking for top tier business development and operations Okay, so yeah, if you're looking for particular people, that's probably not for me. So okay, sorry about that. Can I get a legal stock purchase agreement document? Where can I get a stock purchase agreement, shareholder agreements, other legal documents co-founders and investors need to sign? Clerky is one online source that I've seen a lot of people use to form their companies. They have those sorts of agreements. So you can certainly look at Clerky, LegalZoom.com, although I think Clerky is quickly becoming a favorite among a lot of startups. But I would still say, notwithstanding, they're not a law firm, they can't provide legal advice. So the best thing you can do is make sure at some point early on as possible, get some good legal advice. So thoughts on choosing board members and patent strategies. Value of revenues is a function of when should you talk to a VC, after 5 million, 10. Well, I mean, so a lot of companies are looking for VC investments pre-revenue. So you don't have to have revenue to talk to a VC. Again, it depends on know your investor, know your VC firm that you want to go to. If they do invest in pre-revenue companies, then obviously that you don't have to have revenue for them. Some are looking for revenue. I wouldn't say there's any particular magic marker of 5 million, 10 million, 50 million. other than knowing the particular appetite and sort of process and targets that VCs are looking at, what kind of companies are they investing in. Board members, oftentimes when you first set up a company, you're going to be, founder will be the board member, but at some point you should be looking to bring good people on that you get along with, that you know, that you think have good experience, that can add value. It's really adding value to the company, but it's a control issue too, because, you know, a board member is going to have a vote. So you want to make sure you factor in who's going to have control of the board. Early on, the founders typically want to control the board. Later on, as you add more investors and you know, VC investors will come in and may want a board seat, you may lose control at a certain point. So it's thinking about all those issues as well. Okay, so I know there's no way I'm going to get through all these questions. So let me see. Thoughts on founder equity splits with multiple founders. Not quite sure what you're referring to there, but if it's how you divide up the equity amongst the founders, sit down and have a very frank discussion, you know, talk about who's contributing what, someone contributing IP, someone contributing money, someone contributing time. Make sure you all discuss what you think the appropriate values are for that. So there isn't any sort of, you know, buyer's remorse after or seller's remorse afterwards once you've divvied up things. But, you know, it should be fair. It should be done in a way that incentivizes the founders to be working towards the successful, you know, operation of the company. Ideal number of issued or authorized shares. That's really specific to the deal, although oftentimes you'll see anywhere between 10 million to 15 million authorized shares. And then of that authorized shares total, you would then only issue a smaller fraction of that to the initial founders, because you want to leave room for additional issuances to employees, consultants. So you want to have some sort of a pool available to other people. But oftentimes you may issue the majority, so maybe it's 60, 70% to the initial founders and leave 30 or 40% available. Earliest stage in the company development that it makes sense to do a Delaware C-Corp when you first form it. So if you haven't formed it yet, form it in Delaware as a corp before you would go to anywhere else. Yeah, so happy to, so I know we're out of time. It's 1:30 and I know everyone's, you know, got things to do and I don't want to impose on anyone's time. Certainly feel free. I think my information's available on the online, but let me go back and I can give you my information here. So basically, feel free to reach out. I'm available if you have questions or if you wanted to, if you didn't get your question answered, then feel free to give me a call or reach out via email. I'd be happy to chat with you. Really enjoyed spending time with you for the last hour and a half. I know and apologize we weren't able to get to all the questions, but happy to talk to you individually or offline and hopefully try to answer as many of those as I can. So go out there. Hopefully, if you're involved in a startup, best of luck. I wish you all the success in the world. Don't hesitate to reach out if I can ever be of any assistance. It's a great adventure. So wish all of you well, and thank you so much for your time today. Great. Have a great rest of the afternoon or evening, everyone, and hopefully we'll have a chance to meet again. Thank you.